Hey, hello everyone. Yes, Mandy, like no starting trouble. I gave you a wrench back, but just behave yourself down there. Like be a good one, okay? Like none of that, okay? I'm so glad. I can't believe that they are taking YouTube channels away from people that comment. This is ridiculous. Something weird's going on. I noticed something was going on in my sub count. It seems to be a lot of people that follow me too. So yay. Hey Aaron, hey always, and Mandy. Sorry to see the chat's just all blue right now, but hopefully some others will comment a little bit. Hey Charlie, welcome. All right. Mandy, you're gonna love this. I'm gonna start with one of the craziest unfortunate trials. It is about the death of a child, and I hate that. I absolutely hate that. But as far as legally, this woman, Leticia Stauch, remember this name because this one, she's a she's a piece of work. I'll tell you that. Not only is she up for murder, okay, but if you'll remember some of my reporting from months ago, this is the one that keeps writing to the judge. Okay, she wrote letters. She wanted to do her defense. She refuses to show up in the court. She's just thinks that she knows better than the law. She knows everything. She's trying to absolutely manage everything herself. And I'm telling you, it's not looking too good for her. It's really not. But let me show. This is Leticia. Okay, all right. And let me just tell you a little bit about Leticia. Well, Leticia, let's just tell you what she was indicted for. Okay. Unfortunately, it is the death of a minor, her stepson Gannon, and she's got murder in the first degree, child under the age of 12 from a position of trust. Okay. She's got child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. They say that on or about January 27th of 2020 in the county of El Paso in Texas, in the state of Colorado, I'm sorry, not Texas, the defendant committed these crimes. Okay. Yeah, Erin, she's just a whole mess. Okay. But listen, after considering back and forth whether she needs to go into for another mental health evaluation, okay, I gotta bring you up to date. Let's go to like the beginning of October. She's been accused of the murdering of Gannon Stauch back in January of 2020, as I just read, and then trying to pass it off as a runaway case, tried to say that he was just missing, that he ran away. His remains were found in a suitcase under a highway in Florida 2 months after his disappearance. He'd been brutally harmed before his death, according to investigators. Okay. She was arrested in South Carolina 5 weeks to the day after Gannon was reported missing. And despite a couple attempts by her lawyers to allow her to bond out, she still remains in El Paso County Jail since she was extradited back to Colorado from Florida in March of 2020. Okay. Um, let me say, Stauch is 39 years old, and since her first court appearance, it's been a bump after bump. They say it is a legal quagmire. She's pulling it all over. Um, because of the pandemic, and then a brief attempt by her to represent herself as she was writing to the judge. I kid you not, writing to the judge directly. You know. Yep. Mm. I'm telling you, wrote directly to him, complaining about her lawyers, but complaining about the way she was being treated. She stalled the process for months while the court waited for results of the evaluation on her, which is not the first. I think we're going into the third. I think the third one was denied. She changed her plea from not guilty to not guilty by reason of insanity in February. And then a few short months after a judge ruled that there was sufficient evidence against her to move the case to a trial. In other words, they were going to trial whether she could or not. An insanity plea requires the state to conduct a mental health evaluation. So again, she got another delay. uh, Ever since, again and again and again, they would convene to discuss the results, and she And the judge would be told that more time was needed. Finally, in late July, Judge Gregory Werner warned if the evaluation wasn't finished in another 4 weeks, a state hospital would be required to explain to the court why the mental health evaluation wasn't done. They went on for months. Okay. Stauch was required to attend a conference this August to go over the results of the assessment. While the findings were restricted and media was not made privy to the details, someone in the courtroom heard the judge use the word sane in reference to the evaluation. The defense then asked for another sanity evaluation conducted by their own experts, and the judge then scheduled a hearing for September 15th to discuss that request. So fast forwarding now to what would be I believe mid-September, okay? The judge Warner said he would consider a second evaluation and then scheduled another hearing, which was this October, around the middle of the month again, on the 13th, to hear testimony from the commander at the El Paso County Jail and the defense-appointed psychiatrist, back and forth to see how she had been behaving. The judge said he would use that testimony to weigh whether or not another evaluation would be necessary. So here we go. Also under discussion in that October is the concern that prosecutors raised that Stauch will be housed if how she will be housed and where she will be having this evaluation if an outside psychiatrist does her next evaluation. She had been in a state hospital, but prosecutors told the judge the hospital might refuse to hold her if its staff isn't doing the evaluation. And so that went back and forth for a little while. Stauch arrived at her hearing on that Thursday, apparently, because they were told that they would use any means possible to get her there. She keeps saying she won't attend her own hearings. And here's the thing, when it has to do legally with your mental health and your competency for standing trial or whether you can represent yourself, you need to be there. They are not allowed to act. They should. It's written that you they require you there in attendance. Um, this was a big thing. She was refusing to attend, refusing to leave. Okay. She said a couple of times that it was hygiene issues that had kept her from the court previously, alleging at one point that inmates weren't being given toilet paper. And she also complained about a lack of air conditioning in the transport van. She wasn't going to go because it was too hot in the van to travel. Okay. She used every excuse you could think of not to show up in court. But Warner said whatever the reason is, she will be in that courtroom going forward, and whether she wants to or not. One thing you do not have a choice about going forward is whether or not you're going to appear. And that's where he left that. Okay. It gets worse. As if, right? Hmm. You're going to think, couldn't possibly, but hmm. I'm going to show you. I have to read this letter because then I'm going to tell you what happened after this last letter in February of 21 went out. And although it's ridiculous, I decided I was going to read it to you because I just can't deal with this on my own. Okay? It's too much for me. This is the redacted version of the letter that Leticia handwrote to Judge Warner in February of 2021. Okay. Judge Warner, conflict hearing info. On February 19th of 2021, I was unable to talk with Judge Bain about my conflicts with my defense team due to the actual privacy of the booth and the transport over. I explained in detail to him expressing my concerns of privacy. I had a very difficult morning mentally because I am not mentally well. One of the main issues with my attorneys is their lack of ability to gather evidence. Due to this, I find little value in the term expert. First, they were unable to obtain my mental health records from Charleston, South Carolina, when I finally paid a firm in South Carolina to obtain them. In 2016, I was diagnosed with and received treatment before work for over 28 hours of care. You'll see that her actual diagnosis is redacted, as it should be. The school district even provided extra services and later let me medically resign due to the ongoing reality breaks. In 2018, I was hospitalized in Canada, crossing the border for 2 days, and completed more of outpatient treatment when I returned. I tell you this because it sets the stage for why I cannot work with my attorneys. I signed release forms for them to get all this information so they would have a better understanding of why I'm all over the place some days. I asked them to use the info from a non biased doctor who worked with me more than 2 hours, but instead they sent a lady who was clearly an actress and friends with the DA. She spoke about him in an unprofessional manner, their history, and his election. Now I'm sure all this was true, but I thought she worked for the court, not one particular side. My attorneys did this to make me look like a perjurious individual. Instead, it was malfeasance on their part. I have included several reasons to support my claim as I kept a timeline of these conflicts. Communication is broken beyond repair. I explained these issues to Judge Bain, including the lack of access and visitations in complete detail. There were other letters. Inconsiderate of evidence. Since March 2020, I asked my attorneys to preserve the GameStop footage, to locate the Texas police officer whom I spoke with, and to get the cruise passenger list. Instead, they spent months contacting my family for mitigation. When asked certain things, they kept saying they will let the investigators know. 1 year later, same answer. My evidence. I haven't physically seen any while being held at the county jail for a year. Yes, COVID, but inmates were still being held as our constitutional rights were adjusted, overlooking statute and evidence. They overlooked the complete statute about video recording. Human error? Okay, but this happens often with evidence in which me, the non expert, has to provide corrections to evidence. Sharing info. They were texting my family and giving them info that they should not have, causing several disputes. In other words, her family wasn't corroborating all the information that she said in the investigation, in the interviews that they're required to give in the investigation. And she's upset. My judge. They filed that motion knowing this county would not grant me attorneys to sabotage any chances of a trial by judge. They knew I wanted to present evidence to him without exposing any info on my son's father. However, they created incorrect conflicts instead of addressing the real issues. They could have filed the pro se only instead of talking about my defense to sabotage my trial by judge. Defenses. Indeed, I am innocent, but I will not put myself or others in danger running the defense against my biological son when the system is letting two men run free who are involved. One is a prominent member of an independent business. They use the NGRI to get a hearing, knowing I'm not guilty to cover up their lack of representation. Although I had bouts of insanity, and still do, I did not murder or abuse anyone, nor would that be a defense because it's my understanding that you actually did do it. However, I will protect my bio son and I will protect the drugs and violence documented from my stepson. The truth is, the court is holding the wrong person and for the wrong crimes. This whole process has been nefarious, from denying me an attorney, threatening me in the bathroom away from cameras to confess, taking advantage of me being delusional, threatening my other kids' freedom, or else. I am going to keep making it known, sir, just how much the state has done in this wrongful incarceration. I will continue to be an advocate for myself because I am not a murderer, and the level that the prosecution goes through to promote a wrongful conviction is absurd. Truth is, they could see a video from someone else and they would dismiss that person as a lunatic. They have far too much invested in this wrongful incarceration to admit they are wrong. For these reasons, and because my defense team is in cahoots with them, I am left with no other choice but to represent myself. Denying me my rights under the Constitution has happened throughout this process, from the detectives, the jail, and now my legal team. Every day I am getting worse mentally due to inadequate representation and being held hostage for a crime I did not commit. These are my conflict issues and my reason for asking to go pro se. As always, thank you for your time. Okay. And she mailed it right there to the judge, and it got to be part of the trial. Okay. Part of the evidence is there. Now, when he received that, now you know this judge is definitely going to do something about it, right? What do you think he did? Of course, he ordered a mental evaluation. If she cannot stop interfering with her own trial in this way, and is going to contaminate things and go back and forth, then of course they ordered a mental evaluation, which she passed. And right after that, months it took to get it, of course, and the delays. But as soon as it got received, which was earlier this spring, I think it was March, April, May, maybe. The judge came right through and said she's going to trial. You're saying you're going to trial. Right after that, she starts again. All right. So the first news was that I received was that we did get a trial date. So the trial date for Leticia Stauch has been set for March of 2023. Okay. Because her results for her third mental evaluation are to be completed by December 1st, 2022. The judge does believe that everybody can be ready to go forward by March of 2023. Okay. So, that's reasonable. They have to put this all on there. Okay. They do. They have to get everything due, but definitely, they ordered another evaluation and they ordered a deadline for it. And there you go. All right. But it gets as if that isn't enough. Based on that letter, okay, the beginning of October, I received this. Leticia Stauch has filed a civil lawsuit in federal court. This El Paso County woman, who's accused of murdering her 11-year-old stepson, is now claiming that her civil rights have been violated in the jail. In a federal lawsuit filed last week, Leticia Stauch claimed in a handwritten 13-page letter both her First and Eighth Amendment rights were violated in jail. Stauch names a medical service provider and a food service provider, as well as two El Paso County deputies in the complaint. She claims she's been mistreated while in jail by claiming she was not properly given kosher food and that the jail neglected to give her medical care. So she's not claiming she was beat up or treated ill or anything. She named the food service providers because she wasn't given kosher food. And she named the medical care provider because she says she wasn't given medical care when she needed it. Currently, the case is in initial review, and a judge will decide if it should be dismissed or not. But this could also play a role in her criminal trial. It's going to cause another delay. Stauch's defense team was ordered a second mental health evaluation, of course, to determine her sanity after all of this. This was part of the evidence that they used in weighing that they actually need another case. It is in El Paso, Colorado. Yes, Lisa. El Paso County in Colorado. Well, I don't know. It presents awful, Attorney Stephen Longo said. It's decently well-written complaint that makes specific allegations regarding events that she's making effectively a Section 1983 civil rights claim. Okay, with conversations surrounding her mental health state, Longo points to the impact it could have on the ruling as the case continues. It's generally a complex area of law and it's decently articulated in the complaint. Imagine if you're her defense team. Judge Warner allowed you to change your plea to bring in some of the psychological factors that we've seen, and you're really backtracking. It's kind of one step forward, five steps backwards in this case again. That Stauch is expected in court for the results of the mental health evaluation in late October. We didn't get anything yet that I saw. We're still waiting. Okay. They gave a date now of that has to be by December 1st. But can you believe this? Can you believe this? I'm going to look for. All right. Before I move on to the next person, I'm going to move on. Oh, I put her up for again. And for those of you not aware, this is Where is he? Hmm. Nope. I thought I had the picture of Gannon, but I don't have it up here. So let me look if you've got comments here. Erin says she may get certain treatment and considerations while in court, but she's not getting an insanity plea. This is true. She's not getting an insanity plea. I know. She's not even remotely remorseful. And I agree, T King, with this one. Nothing surprises me with this one. She is really, really, guess how much we care if that murderer likes her food? Nada, zero, zip, none. Mandy, I'm with you. Like, you're being held on charges. Human treatment is right. Special dietary concerns like allergies, I can understand. But all of a sudden with her religion and everything, this is like paramount, but it wasn't filled out in the beginning. It just occurred after she lost her plea, for insanity because she's fit for trial. Yeah. So she is not guilty because she was insane when she did it, or did she not do it at all? She can't seem to decide what her defense is. Exactly. You know, T. King says she is guilty. She needs to just stop with the game. She's been playing games all along. She got caught with the suitcase. He was in the suitcase, her suitcase in Florida. Oh, they have it. Like she tried to keep. If you go back to some of the older reporting, if you search her name when you go to the playlist for my updates, my legal crime updates, and you just put in Stauch, because I put it in the title when I cover them, it'll come up and it'll show you all the evidence she tried to get rid of. The phone, which showed her exact location, that she was home with him at the time, that the conversations she had with her daughter, who is actually giving testimony to the investigators, the conversations she had with her husband, again, Gannon's father, in regards to jealousy of the fact that the kids were taking up too much of his time. And Gannon's sin was actually being sick that day and being home with a stomach ache, and it interfered with her plans for the day. And there is a text and phone calls going back and forth. She tried to get the phone out, saying that that phone could have belonged to anybody. It wasn't hers. It's been registered for her for I don't know how many years, whatever. And yeah, hmm it wasn't hers. It could have been cloned. She got a lot of great excuses for stuff. Yep. Yep. The disposal and the attempt to hide the body automatically established mens rea. No insanity defense is possible. You're up on the law. And in Colorado, as long as she's sane, you're right. Even temporary is not going to work here. She can't even say she had a moment. Okay. Hmm. I think there is a constitutional right to have kosher food. There could be small, cute puppy. I'm not aware. What we're saying is like we think she's got a lot of nerve to sue about it. I don't think, and she's only suing one person. So we think it was only like one or two meals she wasn't given, like because she's suing one person, not the whole, just not the whole jail. She's not suing like the whole kitchen uh department or the people. She's suing one person in that department that she may have had an altercation with about a single meal. I'm going to have to try to get the civil lawsuit paperwork, but a lot of this about Leticia is been under wraps because of the mental health issue. Hmm. Oh, you want to starve on Nutriloaf? It has all the nutrients you need. They put your entire meal in a blender and then bake it into a loaf. Ew, that sounds gross. Yeah, I know, Mrs. Cassandra. Makes you sick when you use kids tend to take a lot of time up and energy, but you made the choice to have them. I agree. She married a man with children. She's not going to she actually was jealous of the stepchildren. There are many texts that I saw in the indictment back and forth they say, as to motive. Mm. Well, okay. Well, if you have no more questions about Leticia, I've got more. I got more nutcase for you. Yeah. put up. We're gonna play picture roulette, and the first one to come up is the one I'm gonna do. Oh, this is not a pleasant face. Here we go. Not too much, Kyle Wilson. We just talked about Leticia Stauch was the first one, and we're finished with her right now. Well, you can always go back. They was it was entertaining, at least for me, because I'm getting, I'm just saying it is. For me, Leticia is quite hmm, legally the shenanigans that are going on is just like beyond me, beyond, and I just so it's somewhat, I don't want to use the word entertaining, but it's amusing to see the lengths that she will go to, because I really believe that she's just not very right at all, um at all. Okay, well, everybody knows who this is, I think. Okay, this is Alex Murdaugh. Okay. And I did do a little bit on him a few weeks ago to say that the murder trial has been moved up a week. So it would be on the 23rd and not the end of the month. Okay. But there's more going on, because months after accusing Alex Murdaugh of killing his wife and son, the investigators and prosecutors, they released very few details on the evidence going back and forth, okay? And Alex's defense attorneys are arguing that there's some kind of unknown DNA under mm, under the wife's fingernails, okay? And they're trying to actually indicate, remember we were talking about Curtis Eddie Smith, he was drug partners with. They were selling drugs together, and he's the one that he commissioned by paying him to try to assassinate him by shooting him in the head on the side of the road. And all of that shenanigans, trying to get out of like getting charged for all of this stuff, okay? Um the defense is boosting documents about the story of Smith, and that the prosecutors like have no evidence that back up Smith's story, but they're saying that, that the son possibly killed the mother, and because he caught her with a groundskeeper. hmm Alex is besmirching his wife, rather, not his mother, his wife and his son after they're dead, and this is his like last ditch effort to try to get a new story out there of what's going on. Okay. Now, granted, it did take like 13 months for the authorities to indict Murdaugh, and they did indict him on 2 counts of murder. And it is going to begin this January, not at the end of the month, but on the 23rd. Um, and because the actual defense attorneys want it done as quickly as possible, they're the ones that requested that it be moved up. Now, Alex Murdaugh has been claiming innocence all along. You know, they they put out their indictment, but they put very little out there on the physical evidence that they're actually going to release on how they've linked Murdaugh to the deaths, or why the defense is claiming that this man has no criminal history and he's part of a well-connected family that dominated the legal committee in Hampton County. Why would he want to kill his own family members? Okay. But here's the hook. Okay. Anyone that's been paying attention to this case, could you not say that there are at least 4 or 5 other suspicious deaths related to the Murdaugh family and actually Alex Murdaugh's immediate family? There's the boating accident. There's the kid that's friends with both his sons, found on the side of the road, mysteriously dead. There is the housekeeper that mysteriously died on his property. Okay, which he lost that lawsuit. He's got criminal charges for absconding with the money for insurance for, claims that he put, and he goes to court and he gets these insurance awards and then he keeps the money. Just There's fraud, there's abuse. He's lost his license to practice law, and these defense attorneys actually have the gall to say that he is from a legal community with high standing, and he's wealthy, well-connected family that dominated the legal community. He has no criminal history. They just awarded a $4.5 million settlement from the Satterfields, which was the maid. The family won that lawsuit and said that he settled it though. He actually agreed to give them all this plus, and he's gonna come up just because he hasn't faced the criminal charges of it. In the civil suit, he admitted to doing it. How do you get, I know it's semantics. They get to say it because he hasn't actually got a criminal charge for it yet. But they're coming for him on it. You all know, I've been reporting he's got 80 charges on fraud and insurance fraud and bad practice, malpractice, scamming business partners, scamming clients. This is bad, okay? But the nerve of his highfalutin, and he is a very well connected politically, his defense attorney is way up there. Okay. I get it, you know. It's Dick Harpootlian, okay, and anybody in that area knows that name. He's well up there. He tried to get out of the trial because he had other commitments, that he wanted to attend to that were more fun. Oh, it didn't work. Okay. So then he pushed to move it forward fast. They want to get it over done with. Okay. So they are actually working this PR campaign to get this out there about this. Okay. And using this kind of terminology. And the reason I'm talking about Alex Murdaugh today is because, wow, I guess he's getting his money worth out of Dick Harpootlian. Okay. He definitely is. He definitely is. Okay. Well, here's the other thing. The timeline has changed from the beginning in the leaks and from the indictment. They always said that both his wife and his son died between 9 and 9:30. Based on pushback from the defense, the prosecutors are now opening up that window to say, nope, you know what? We got evidence, and we're going to now tell you, okay, that we're looking between 8:45 and 10:06. Now try to tell us he wasn't anywhere there, okay? He made that frantic 911 call to report the bodies after he left where the bodies were at 9:06 p.m. Okay, so they've now opened up the window because they now have the forensic evidence of when exactly the phone call was made, where the phone call was made, okay, and exact timing. So they've opened that up to try to defer some of this that they're saying that no. If it was 9 o'clock, then no way he could have done it because he made the call. And now that they finally have turned over all of the phones and the devices, and they finally have all of the reporting on that from forensics, they've opened up the timeline to say 8:44 to 10:06, which is not an unreasonable timeline. Murdaugh's attorneys have requested the FBI report that analyzed that cell phone data because they said that it is very crucial to their defense. They're going to try to knock it back to the original 9 to 9:30. Okay. There is nothing to indicate in the next 20 minutes that he butchers his son, his wife, executes both of them in a brutal way. That's what Dick Harpootlian is saying. He's then on the phone talking to another lawyer from his car in a very convivial way. Okay, they're trying to say because he was able to make phone calls within the hour afterwards, that it wasn't him. Now, we know that two different guns were used. That's evidence that's been here that we've talked about before. Okay. Um, the authorities have not tested Smith's DNA, okay, to the DNA that was found there yet. I don't know if that's still going to be done or if they're just not releasing it, okay? But the defense is actually pushing really hard that Smith is more likely to have done it than Murdaugh, even though they can prove that Murdaugh was there. Okay. And there is actually some evidence coming forward that Paul, the son, has a video on his phone of his mother talking to somebody, his father, it is assumed, in a very agitated manner prior to this happening. Okay. Mm. Anyway, it's clear that the pretrial back and forth of these prosecution and the defense is just going to keep going and going. Okay, the prosecution has not listed eyewitnesses, okay, or any video of the murder. They're saying so you don't have anybody that saw it, so you don't really know. Okay, so we don't know that Alex has killed Maggie and Paul. Okay. We do know that it happened on June 7th of 2021. And we do know that Alex Murdaugh was there. And we do know that he's the one who called in the 911 as he was leaving the property. The prosecution is saying that although this is very well stated and that you could put whatever story you're out there, every murder doesn't need a confession or an eyewitness for it to actually be a conviction, and we all know that. I mean, it would be nice if Murdaugh would just confess, but based on everything that he's looking at, I mean, he's making calls from the jail to his son and to his brother and to his uncles about, they froze all his assets and he was trying to get stuff moved days before that all happened. He's having allegations come at him civilly and going to be criminal charges about the absconding of all these funds. I mean, the family's in dire straits. I mean, he's making a mess of everything. You would think he would want this over and done with, but I don't know. Maybe the more they drag this out, um, the better. But they actually want to have the trial faster, January 23rd, you know? Hmm. Anyway, the prosecution is saying that it is a salacious scuttlebutt and it's offensive to the memory of the victims. The way the defense is trying to put out a story of Maggie having an affair, there's actually no evidence of this affair. That we don't know what they're talking about. They've talked to Smith in regards to this. They did say that Smith's test is going to be tested, okay, and that the results of a lie detector test aren't admissible in court by themselves, but they're confident, um, you know, that they don't feel that this is anything. Defense is saying that because Smith was nervous during the polygraph, that those circumstances believe that he believes that he's possibly implicated in the murder himself, and that he is the murderer, when we all know that these polygraphs are not admissible in evidence and they pick up emotional spikes. Smith was already confessed to everything else that he did. He could possibly just be feeling nervous because he's being questioned again and he doesn't know what else he's going to confess to because he hasn't done anything else. So I don't know. You got a deal on the table about everything else you did, and then they're coming at you about something else. Obviously, you're going to be nervous. I mean, to me, it seems reasonable. But for the defense to try to use it when they know it's not admissible in court just proves that this is a PR thing to try. And that's what's really got me going, because this is like a PR move on their side to try to discredit everything, and they are actually discrediting the victims. They are actually slandering on the victims. Okay. They're saying Paul did it to his mother because of an affair that no one has evidence she even had. Okay. All reports from everyone who knows the family says, no, they don't think so. Mm. It is really hard that they want to make it about the other guy. They're really trying to throw these doubt in there. And if as the defense attorney, I can't say that that's not something they should be doing. I know. Mm-mm, mm-mm. And small cute puppy says maybe they want the trial faster before the prosecution can get the DNA analysis done. Maybe, but they're the ones calling for it, right? Like, doesn't that like ring bells to you? I don't know. I don't know, but there is so much going on. The fact that they call him an upstanding citizen of the community, of the legal community, when he lost his license and he's got claims against him by everything. He had to turn it in before they like hauled his butt in. He's got like 80 counts of fraud and misuse of funds and malpractice and bank fraud, insurance fraud. Mm, it was a little offensive, which is why he made the show. Which is why he made the show. I just couldn't. I could not let that just go by. I'm just saying. Okay. Oh, so that new timeline. I'm trying to find out exactly why they said they're going to move the timeline. Oh, it says that they did not explain it. They just listed what it was because it was asked for by the defense. So they were being more clear. And that is all they'll say about it. Murdaugh, who has pled not guilty to the murder charges, said he found the bodies and reported the grim discovery in an emotional 911 call from the property at 10:07 p.m. The court filing did not explain the new timeline, but they've reached out to Murdaugh's attorneys who said they were pushing the prosecution to actually put into place the actual timeline. Okay. In August hearing, they revealed that video and audio obtained from the son, Paul Murdaugh, captured a conversation between Alex and his wife Maggie and the son that took place at Moselle, the property where Maggie and Paul Murdaugh's bodies were found. That would place Alex at the property and the crime scene at the time of the recording. The recording is what starts the actual timeline at 8:44 p.m., placing Alex Murdaugh at the scene with the victims within the window that the crime committed. This is tough. So the window is now 8:44 and they're ending it at 10:07 because that's when he made the 911 call. So they're not actually this is all they'll lay out for them. They're not saying what other evidence they have, but they're saying they got the video, like I said, of Paul's phone talking with Alex and Maggie and the son, and it took place on the property. They're able to pull that all up. Um, I don't think the defense is doing much good by asking for a firmer timeline because now they know that there's video evidence, and that's gonna be rough to go against. Okay, and they said that the prosecutors are claiming that that is when, after the phone call, the prosecutor said that Alex had fired up his car and left the property around 9 something for Alameda, where his father lived. And the 911 call was then placed when he was off the property at 10:07, and it was made from the Moselle property, the police records show. Okay. So Alex is saying that he left, okay, but the 911 call says that it was done from the Moselle property. So there's a little confusion there. Hmm. No, 911. I'm sorry. It's 911. They'll try to paint everything as part of a huge slander campaign, law license included. Uh you know what? He's been found guilty and he actually admitted with the maid that he appropriated. He actually settled with them for more than the amount. And that family actually took that money and they made a foundation instead of keeping it. Mhm. Do I need to read this? Okay. Well, okay. Ganymede says my cat just pooped and it smells like onion. And yes, I had to read it for £2. Thank you very much for your contributions that we'll be donating at the end of the quarter. Thank you for that. Mm. I know this is the face, right? This is why I picked this picture. Do you see the smirking and his lawyer and all? And Sean, it's just so upsetting to me. It really is that he goes that way. Hey, Wrecker. Wrecker says he sounds like a trustworthy guy. Oh, yeah, I'd invest with him. You know? Yeah, I would invest money with this guy, sure. Yeah. Appreciate it, Gainy Meat. But anyway. Any questions in regards? Any questions in regards to Alex Murdaugh? Before I got one more for you. We're loaded tonight with these. This is ridiculousness. Like, he ate your sock. Is that why? Oh, you. And it smells like onion. Hmm. Why is he bald? I don't know. He has a long history of some mental instability with drug use and all, and depression. I don't know. He's also older. He's in his 50s. Some men lose early, I guess, but that's a good question. I know I asked for questions, Kyle, so you gave me a question. Okay. Thank you for that. Okay. Remember, he's trying to protect his good name among his peers. Never mind the fact that it's like painting a house while it's on fire. Exactly. It is all burnt to the ground. The family would do very well to just distance themselves. And by the way, his own family kicked him out of the partnership. Here it is. This well-respected family that's all lawyers and politicians in the area. They went hail to the no, like yeah, boom. They had a meeting. They renamed they renamed the law practice. They took the Murdaugh name off of it because he's besmirched it so badly with the 80 different filings against him, 80 different charges against him for just misuse of the funds and fraud in regards to the law firm. Okay. Some of these charges are from the law firm itself. His own family members and partners, okay, are actually suing him. All right. Some of these charges are right from them. Some of them are federal. Some of them are civil, criminal and civil. He is up to his neck in paperwork. Like this lawyers, he must have a whole fleet of them to handle this stuff. It's just too much. I'm not gonna ask Jen, I don't know why. It could be that you're just that handsome. I don't know. Or it's that cold and they're sticking out. I don't know what to tell you. So, are there any of his kids still alive other than the son he's blaming it on? Yes, there is. His older son. He killed Paul. Like he's being accused of killing Paul, and he's actually blaming his that Paul murdered his mother. Okay, but he doesn't say how Paul ended up dead. Yeah, but there's that. But based on the defense saying that there's nothing ever. It's such an upstanding family. There are so many. There's a boating accident where they lied on who was driving, and he tried to politically make some maneuvers there on who was driving. And there's a bunch of lawsuits going on with that against Paul, actually the son. Right before his death, they were actually going to have to, and they were announcing that they were going to go to trial on that. He was going to be indicted for all the allegations about misrepresenting, drinking under the age, causing an accident that caused a young woman's death. Okay. And then they just tried to hide all this. They tried to obstruct the investigation and they hid a bunch of evidence. These are the claims, these are the allegations. There's civil suits going on. There's still an investigation going on. Then there was a young man by the last name of Smith who was found on the side of the road after an altercation with which a group of people say that they saw the sons and everybody else, more than just them around, and nobody was talking about it. Nobody, yeah, they all just clammed up on that too. Okay, then there was the accidental death falling down the stairs of his maid. Okay, which was the third in the series. The allegation is there's the speculation, I should say, with absolutely not a stitch of evidence that I can find, is that maybe she knew something about one or those other situations or overheard something. Who knows? All I know is that when he did sign on with the family to go to the insurance company to get a big settlement for her, got the settlement, and then didn't give them the money. So, it's not beyond him. I don't know. I don't know. I don't know where Claire is from, but I hear Brooklyn, South African, and British in the accent. Anyways, I won't spam your chat anymore. Good night. I'm from New Jersey, if that eases your mind. Maybe they all come together to be New Jersey. I don't know. But I've heard all of that from so many people. I don't know who you are, but you're fine. It doesn't bother me at all. This is just how I speak. Mm. And thank you, small cute puppy, for remembering where I'm from. Yep. Yeah, Erin, she tripped and fell up the stairs, the maid. Yep. That's how it happened. You know. Oh, but thank you for being here, Ganymede. Mm. All right, let's go on. I have another for you. If you will, let's get him off the screen, eh? Hmm. Let me find you something. I can't say it'll be more pleasant because these people are not pleasant to me at all. Okay. Hmm. Yup. We've got news on Chad Daybell and Lori Vallow. Okay. Now, we know that Lori Vallow's case has been held, not stayed, but just held while she goes over and she's having another evaluation. We reported that a week or so ago. That's still going on. We don't have any other results like that. That's sealed. Okay. So they did actually have movement on the case. And if you look down below, I always give you the cases of interest for Idaho. That's all out in the open. It takes a couple of days to come up, and everything just comes up. After a few days, you can get to them. But anything to do with Lori's mental health is ordered sealed. And that could include like why they're delaying things and things like that. However, there has been motions on both parties had, like I said, they wanted a particle bill where they list out all the evidence that they have against them. The prosecution is supposed to prepare some other document to, lap out how, basically get a peek into what they're going to present. But the judge squashed both of their requests, both Lori Vallow DayBell and Chad Daybell. Both those attorneys got motions back. They said, nope, not having it. You got enough in your indictments to say what the evidence was, what the case is against them. We've got pretrial hearings where there was a discovery. You know what's out there. But in the Daybell side, they were complaining because the amount of phone records they had to go through was so much. They wanted the prosecution to give them a hit list of where they should be looking. I found that quite amusing. It's like, hey, you're going to pay the prosecution for that? Like, that's your job, right? Uh, Also, Daybell wanted to get the trial delayed, and that's been denied because, well, not exactly denied. Okay. Um, and I'm going to pull some of that up too. They actually, well, let me go to the other stuff. As far as separation, they have not actually read on that yet. And I don't think that they're going to anytime really soon. Um, there is a Mm. I think there may be a reason. I'm not a lawyer, but with Lori's mental health, I understand what I want. I know why the prosecution wants to keep it together. There's a strong argument that we need to keep it together because it's the same murder at the same place. They were both there, okay? And we need to keep it all together for the evidence so there's no finger pointing, this, that, and the other thing. But there are all these loopholes that are getting thrown in. And the two main ones are the status of Lori's mental health and the fact that Lori wants an expedient trial and she won't waive. Okay, she wants an expedient trial, and Chad Daybell keeps requesting for more time. His lawyer keeps saying he does not have enough time to present, that this is a capital case. He needs even more time because of the sentencing. Okay. And that he just needs more time. He just keeps pushing this to the judge. And that is why when we get to it, I'm going to actually read the judge's order to you because I actually was thrilled with it. But the other thing that for Chad Daybell and Lori Vallow is that their supplement discovery of disclosure is actually approved. Defense counsel is actually going to be able to inspect and copy or photograph the items of material described in the Idaho criminal record by simply making prior arrangements from the Madison County Prosecutor's Office. In addition to the above, the state may also utilize the following as evidence in trial. The Bode Technology Forensic Case Report regarding the in the ISFP Lab Report 13 previously provided in July 27, 2022. Now, they both have issues with that, but they're both going to be able to use it, okay? And now they're saying discovery is open, but they're saying the prosecution does not have to prepare a detail to them. They're just allowed to go look at everything that they have, make photocopies of items if they want to, and material described, okay? Period. That was their ruling on that after Daybell and Vallow's attorneys both actually went forward to say that they won't. Now, Daybell is also actually still pushing for a motion to sever, okay? And they did not hear that yet, but what they did say, they did put out a notice of hearing, okay? And they're saying that November 10th, that's only 3 days away. 3 days away, they're going to have that hearing, okay? On whether or not these two cases are going to get separated, okay? And that's going to be in Fremont County Courthouse, okay? It's still Stephen Boyce. He's still the judge, has been all along, okay? Well, not all along, but for the actual pretrial motions forward, okay? All right. Now, here's some fun, okay? The memorandum and decision in order from Judge Boyce, okay? Before the court is defendant Chad Guy Daybell's motion to continue trial to enforce Mr. Daybell's constitutional rights. Daybell filed the motion on September 27th, and on October 6th, the state of Idaho filed a response to Daybell's motion to continue. On October 13th, the court called the motion for hearing, and the parties presented arguments in support of their respective positions. In addition, the parties were provided additional time to submit further information regarding their assertions that discovery was still active in the case. The court was therefore advised that discovery continued relating to evidentiary issues, including DNA evidence, electronic device analysis, and cell phone server data. Having fully received the briefing, the record, and all relevant legal authority, the court now renders the following decision. Like they're just explaining why it took so long, why it took so long. Okay. Procedural background. Court minutes reflect that on December 2nd of 2021, the court held a scheduling conference in this case wherein counsel for Daybell argued that Daybell's trial to begin in October of 2022. The state of Idaho requested trial to commence late summer or fall of 2023. Ultimately, after coordinating with Ada County, where trial will be held, the court set trial for January 9th of 2023 and issued a scheduling order. On September 27th, Daybell filed a motion to continue that trial, arguing that substantial amount of trial investigation and preparation and significant amount of discovery was still outstanding. On October 6th, 2022, the state filed a response to the motion, essentially as a non-objection to a continuance, and requested the court to stay this case, pending the determination of a new trial date for the co-defendant's case, who is Lori Vallow. On October 13th, the court heard the parties on the motion in a hearing and took the matter under advisement. And the court is now ordering as follows. The decision to grant or deny a motion to continue rests within the sound discretion of the trial court. Where the denial of a motion to continue is attacked on the basis of late disclosure or discovery of evidence, the alleged tardiness of the disclosure must be shown to be so prejudicial the defendant's case preparation that a fair trial would be denied. Okay? To prove prejudice, a defendant must show there is reasonable probability that for the late disclosure of evidence, the results of the proceedings would have been different. Further, the bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for continuance. Initially, the court reiterates that it has denied the state's request to enter a stay in this case, requested on the basis of a stay currently affecting the companion case. Next, addressing the defendant's motion to continue trial, the court notes that during the hearing on October 13th, counsel for Daybell again emphasized that he could and would be ready to proceed to trial on January 9th, 2022. However, counsel also represented that significant amounts of discovery were still outstanding and made the request to continue trial in order to abate any possible prejudice to the state. The motion argues that defendant is entitled to an adequate amount of time to prepare for a capital trial, and the court agrees. All parties have been aware that this is a capital case since August 5th of 2021. Notice of intent to seek the death penalty was filed then by the state. In considering that this is a capital case, the court has at every juncture been mindful of protecting all aspects of ensuring a fair proceeding to the parties involved. The court also took into consideration setting a trial date in January of 2023. The representation of counsel that the defense would be ready for trial by October 2022 then, and objected to the trial being set into 2023. The basis argued in the motion to continue reveals the unfortunate current posture of this case, where only now, too late, counsel fully realizes the complexity of preparing a defense for this case. The motion to continue cites, amongst its many reasons to delay the trial, to constitutional rights, to effective assistance of counsel, the required individualized sentencing proceeding associated with a capital case, and the need for experts and development of mitigating evidence, and the purely speculative argument that some other attorney may at some point join the defense team, and the new attorney would need additional time to prepare. While the court is left questioning how and why such issues, all present at the outset of this case, are only now being asserted as a basis for continuance, the arguments as a whole leave this court with the abiding sense the defense has indeed demonstrated that it is not and cannot be ready for trial in January 23 of 2023. The ongoing insistence at times that the defendant is ready to proceed to trial, including representation made during the October 13, 2022 hearing of this motion, are contradicted by the assertions in the motion itself, which leaves this court to determine that a trial in January 2023 would in all likelihood result in defense counsel's inability to be adequately prepared, thus infringing on the defendant's right. So, thus, despite the preparations the court has already taken at considerable time and expense, including multiple on site visits and coordination efforts with Ada County, wherein counsel for the parties has also been present, to hold this trial in January, this trial must be vacated and continued. Having previously established that the defendant has waived his right to a speedy trial, the court must ensure that the defendant has a full and meaningful opportunity to prepare a defense. The court will contact counsel to reschedule the trial. The court expects counsel for the parties to have a full and complete understanding of what preparations remain in rescheduling the trial so as to avoid any further unnecessary delay in the administration of time. So, for foregoing reasons, the defendant's motion to continue trial is granted. Ugh. Now, the reason I read that is I'm sure you all heard how pissed that judge is at the defense. Okay. Hello, Mr. Malort. Mm. I I had to read it because did you not hear what that judge was saying? He's like, "Yo, you told me over and over again you were ready and you wanted a speedy trial. You wanted separation from Lori because she was being held and you wanted a speedy trial. You were ready to go. You were ready to go. And now that we haven't separated the trials, all of a sudden you're not." Hmm. Hmm. Yep. Mm-mm-mm. Mm-mm-mm-mm-mm. I'm telling you. I know. Oh, and Kyle, thank you. It's not ridiculous. I am from New Jersey, but I am Irish. I am clearly Irish, and English and Polish. Mm. What did your super chat do, Ganymede? We donate all our super chats to charity. And every quarter we add it up, and the members and the Patreons get to vote on where it goes along with the memberships. It also helps also smaller creators who need equipment and some other little things that we do, but I don't really keep it to pay my bills. So that's what it did. Hmm. Right. I'm sorry, Aaron, but in this case, because it is these kids, I've been following it for so long. Um, it do I need you to see the victims on this one. I need to see the victims on this one. This shenanigans going on legally with these two, Vallow and Daybell, back and forth, it is driving me up the wall, and I need to focus on the fact that we want justice. We want this to come forward. We want to stick to the legal procedure as best that we can, and I'm trying not to be biased, but I really want to see this trial come forward. And I'm kind of annoyed that Daybell is actually getting his trial delayed. I understand the need. They want to keep them together. The delay may actually be tied in with Lori Vallow now, because now that he's actually gone for a motion to go forward, that gives them time to complete the competency on Lori Vallow, and gives them time to schedule everything based on it to move forward in an expedient manner. They only need a couple months, so they still could keep them together, you know. Uh, um, so I'm hoping that the trial still stays together, or because it will allow less finger pointing, and a better prosecutorial case. And I'm sure that's what the prosecution wants also. It doesn't seem like the judge wants to split it, but the judge Boyce is doing his best to actually make sure they get a fair trial. There is the point that, Daybell is, actually needs to have a fair trial also, and Lori's mental health is compromising that in some way. Okay. But the reason he wants it separated is there were all those rumors in the last report that they actually plan on pointing the fingers at Lori Vallow and Alex Cox, her brother, and say he didn't have anything to do with it. Um, so they need to be farther away from, co-defending, defending, to be able to do that adequately. Okay, with the best. I know. I know, Aaron. I hear you. I know. There's a lot of evidence, and we've all heard about it. Um, it's true. It's true. Yeah. But anyway, we're going a little bit longer here. I'll take some questions on this if you like. Okay. But I just thought that the judge's ruling there was pertinent, because now we do have a delay on both sides. We have a stay, not like a delay on the Vallow side, and now we've got willingness to renegotiate and move it from January for Daybell. So we're looking at possibly March or farther. Um, I don't get the impression from this judge and what I just read that he's going to go very far into the future with this. Remember, though, that in this particular case, in order to have a free trial, Judge Boyce is going all the way to Ada County, in another county, to get the jury and to do a fair trial. They've already agreed to that concession to relocate the trial, but not the judge and the records. Okay. The same judge is going to stay with it, and he's made arrangements with another judge's court to actually go over there and have his trial in Ada County and do that jury pool, because they knew in the county where it was, they would not be able to get jurors based on the children and everything and what happened over the year. They're not going to get jurors that hadn't really been prejudiced. And that was the case. What he's trying not to do is have everything overturned. The Judge Boyce is doing everything he can to go straight down the line and be as fair as he can to both defendants, to make sure that they don't have an appeal, that everything doesn't get overturned. Okay, and so I really feel for him, because this is going on a long time, and I could hear it in what I read, because he's like, "This is ridiculous. Just 2 weeks ago, you told me you're ready to go, and I'm reading this thing that says you're totally unprepared and it's biased if we go forward. But you're saying you're cool, like we could go." And like he's calling him out. He's calling defense out. Like, you should have had a clue. You should have been ready. How dare you even mention another attorney if you haven't hired one? Like, why does that? Why is that? He even said, like, why is that even in there? He's alluding to the fact, what the hell are you mentioning another attorney when you know if you get one, you're supposed to register it with the court? We would know by it by now. And if you bring one in last minute, whose problem is that? It's not necessarily our problem if you can't handle your cost load. It's a capital case, and you got one attorney, Chad Debiel, instead of a whole big lawyer, like a lawyer's office with more than one people, lots of people. It's a capital case. This attorney seems overwhelmed all of a sudden with the weight of it. Things aren't going his way. And the judge is calling him out for it. hmm Yes, Mr. Maylord, I see that. Classwood, you're going to be very pleased. I'm going to be making the announcement at the end of the week, but there are some classroom supplies that have been allocated. So we need to talk. Okay. All right. Yep, I agree. People that are going away for life seem to get entertainment from dragging trials out. Hmm. Yeah, I guess they're it's life or death, they're going away for life, definitely. Yeah, if they are guilty, it's going to be a long time. But it's a capital case because they are going for the death penalty here. Can they just relocate the defendants? Maybe like, oh gosh, I, Aaron, I hope YouTube doesn't think that that was actually a threat. Like, there's some crazy stuff going on, but no, I want them, and the families want them to go on trial, and to actually justice to be served. They want to hear what actually happened. I'm sure a confession in like what actually happened to these kids, if that all came out, it would help settle it to rest for them. Not that we want to hear the gory details, I really don't, but I think for the families, they need the process to happen. um they need this, and the longer it drags out for them, uh the harder it is. Okay, because remember, the Vallow never reported her children missing. It was all family members and everybody that hadn't seen them in forever that started this, looking for them, and they had to backtrack into all of this. It is an insane case, for sure. Okay, but on that 1 minute, there we go. At the end of the week, we'll be covering Masterson again. I've got a couple of things coming during the week, but I'm gonna keep it under my hat for now. You know. hmm I know, Aaron. I normally, because of the way our, and I'm not gonna put your comment up because again, you're threatening the life of some defendant. I don't want you to think it's a thing, but here we're gonna go. Is that with when it comes to the death penalty, if of course people that are doing such wrong and are on, you can, I mean, how do you actually say somebody is rehabilitated from doing something so horrific and treating a life like it's not worth anything? I don't know if true rehabilitation is actually uh an ability there. We're not talking manslaughter, we're not talking extenuating circumstances, we're talking just, you know snuff somebody out like that. Um, but the reason I'm not for the death penalty is because the failure of the death penalty system. Because even a few innocent lives, any innocent life that would, someone who is innocent put to death would be something I couldn't attend to. I realize that there's a risk there, but there's too many people on death row now that I see evidence that shouldn't even be there. We just had a man released from DNA evidence after 38 years. Walked out. It couldn't have been him. Could not have been him. Okay. And he was in prison for life. If that was a death sentence, he'd be gone before they exonerated him. And that's kind of like, because there are these loopholes. I know you're not threatening, just okay, I get it. You're not threatening, just demonstrating willingness to act in a legal capacity at the executioner. In other words, you would pull the switch. I get it. I do. And I know you feel like I do about the death penalty because on a broad basis, the system itself fails. And unless it gets better, I don't know how many can support it. But I understand not wanting to pay for them to have a comfortable life, okay, after what they've done to others. I get that. It's a double-edged sword for sure. Okay. Yeah, I know. I get it. And I want to thank you all for your time. And we went over a little bit. But that's it. If you don't have any other questions on that, I'm gonna put on our outro, and I'll see you all during the week. Don't forget to like and comment on the back of the video, share it with others if you like, and for all of the anybody with new accounts, please spread it around that if your account with YouTube got absconded, as I heard many of them do, remember your subscriptions went away, and please do me the courtesy of going back and resubscribing, because it did look like I did something awful last night. Like, there's quite a few of you who had your accounts taken, and you've been sending me messages. Well, please remember to check on your subscription statuses, because apparently YouTube is going crazy in the last 24 hours. Okay. Mm, mm. Oh, Turtle Moves, I've always said I want to retire in the UK. I kind of do. I'm very fond of it. I really would like to. Not because of the no death penalty, but and the legal system there is quite interesting also. Well, it's not a bad idea. But on that, everyone, I'll hope you all have a good night, and I will see you during your week. Yeah, Mrs. Cassandra, when isn't you too crazy? Well, sometimes. Hmm. And a group grope for everybody on the way out, and we'll see you all during the week. Have a good one, everybody.